Okay, so Glenn, welcome back. We have a lot to talk about because, to steal your line, justice matters. All right?
Yeah.
So, again, great to have you on the show. Trump's criminal trial has begun. And you posted a great video last week talking about what the jury in this election fraud case in Manhattan will learn about defendant Trump. And you said, number one, he struck a corrupt deal to shut Stormy Daniels up. Do you remember your other 3 points that you made?
I sure do, Michael. And I take it from paragraph 19 of the district attorney's statement of facts that was released together with the indictment about a year ago now. You know, criminal trials, take it from somebody who's done more than I can ever count. They are in part popularity contests. And Donald Trump, in my opinion, will be the most unpopular person in the room. And I think that one paragraph in the statement of facts really crystallizes that. First of all, he strikes this, corrupt, ugly, dirty little agreement trying to shut Stormy Daniels up, right? Then he tells you, even though you're not named, he's not named either, nor is Stormy Daniels, but it's clear who is being referred to when they say lawyer A and woman number 2, right? Donald Trump, according to the statement of facts, tells you, hey, let's delay payment until after the election. That way, we don't even have to pay her, because if it comes out after the election, it won't hurt me politically. I'm paraphrasing, obviously, right? But think about what the jury will learn about this thing, Donald Trump, right? First of all, he has this, encounter with Stormy Daniels not long after his wife gives birth to his child. Then he tries to pay her to shut her up. Then he tells his lawyer, let's not pay her, let's delay until after the election, the payment. So he tries to stiff her. He enters into this agreement to pay her, and then he's going to try to stiff her on the payment. And he wants to maintain, Michael, that all of this was just to protect Melania from learning this horrible information. Well, that is contradicted by the fact that he says, you know what? Stormy Daniels can disclose what we did after the election and it won't matter. Well, then how is it that you can claim you're being motivated by wanting to protect Melania? I mean, Donald Trump, it's like insult on top of injury, on top of just disgusting conduct, on top of corruption, on top of crime. And I only wish, Michael, in the 30 years I was prosecuting cases, everything from misdemeanors to the biggest RICO case we ever brought in the courts of Washington, D.C., I only wish I had half the incriminating evidence that it looks like Bragg has amassed against Donald Trump. And this is only one of Trump's 4 criminal prosecutions.
And then what are the other points? You see, I know that my listeners might be very upset to hear what I'm going to say. I've made a decision that I am going to not get into any of the sum and substance of the DA's case, any of the documents that I know are going to be put forth to provide my opinion based upon, of course, my firsthand knowledge, because there's no doubt that this podcast, which has already been disclosed, is a question on the jury's questionnaire. Do you listen to Michael Cohen's podcast? Have you read his books, Disloyal or Revenge, and so on? And I don't want to give them more fodder to try to muck the waters up of this, of this first and potentially only criminal case out of the 4. So I'm going to let you do the talking, right, on this completely, because yeah, I can go into what you're saying, but then again, I don't want to provide defense counsel with any benefits moving forward. There's so much that's going on right now, and I'm really just trying to, as it relates to this, there are other things, obviously, to talk about, but this is so relevant, as it is the first in time. It's an unprecedented moment in our history where a former president is in a courtroom, sitting in the defendant's chair, looking at a judge with his lawyers surrounding him before a jury to be decided, right? A jury of his peers to make the ultimate determination of innocence or guilt. So, with that said, what are the other points that you were trying to make?
Well, the point that I was trying to make, just with respect to what Alvin Bragg has in paragraph 19, is that there are so many levels of not just incriminating evidence in that paragraph alone. And of course, it's a 44 paragraph statement of facts. In the federal system, we would call it a speaking indictment, but they do it differently in New York, as all jurisdictions do it their own way. But because the jury, let me tell you, everybody in the courtroom wants to be the most popular person. What do I mean by that? When I was prosecuting cases, I wanted the judge to look to me to be the voice of reason, the voice of authority. When I was arguing that the evidence would prove something, I wanted to make sure there was no doubt the evidence could prove it. When I was citing precedent, when I was citing appellate court authority to a judge, I wanted to be rock solid with what I was representing a particular case stood for. And most importantly, as you know, as a lawyer, Michael, if you have what's called contrary authority, I might have 3 cases that support what I'm arguing to the court, but there's one case that kind of cuts against it. That's called contrary authority. I'm going to be the first one to bring to the court's attention that there is this other case out here, Judge, and it doesn't necessarily help my argument, but let me explain why I can distinguish it. But most importantly, you want the judge to look at you. Every lawyer, I believe, feels this way, as the voice of authority, the person who can be trusted, the person whose opinion is going to be accurate and supported. And the same holds true for, I think, a defendant wants to be popular, wants to be likable. The last thing you want to do, and I prosecuted a lot of bad guys, and I prosecuted a lot of folks who got caught up in situations that kind of spun out of control. They committed crimes, but they were actually kind of remorseful and they regretted it. And, you know, everybody in between. But when a jury looks at a defendant and says, wait a minute, you not only engaged in this conduct with Stormy Daniels, which wasn't a crime, but it may have been unseemly, and then you tried to pay her to keep her mouth shut right on the eve of an election, not years earlier. And then you were going to try to stiff her after you signed an agreement to pay her a certain amount. And now you're lying about it and saying it had nothing to do with the election. It was all about protecting information that you didn't want your wife to know. You know, how many levels of despicability does that involve? Not just criminal conduct, but despicability. And the jurors will be looking at Donald Trump and assessing what they think about him. And not only when he is, you know, appearing to berate his lawyers or blowing up or falling asleep, as has been reported this morning from the courtroom. And that's why I say he's going to be the least popular person in the courtroom, and the jurors will be drawing information from him throughout.
You know,
and
I agree.
It's not going to end well for him.
I agree with you on that, Glenn, because, you know, even the witnesses want to be regarded. They want to be popular, so to say, whether it's with a jury or in a bench trial, just with the judge. I know when I sat for the New York Attorney General case as a witness, at the end, when Judge Engoron made his determination, because I was just watching as I was flipping through channels. I've been really watching like Court Cam, and before that, Below Deck. I'm really trying not to watch any news at all. But I was flipping through and I saw my name pop up, and Chuck Rosenberg was sitting in talking about me on MSNBC. Oh, Michael Cohen comes with a ton of baggage. Fuck you, Chuck, right? I come with a ton of baggage. Everybody has an opinion of me. And then they refer to Judge Jesse Furman, right? The schlock fucking judge here in the city, where I was asking to be released from supervised release. Not only does the guy not do it, but he pulls a Robert Hall, right? The attorney, that special master in that Trump case, which case that Robert Hall, when he started to badmouth Joe Biden, I meant, and Jesse Furman did the same thing here. Oh well, Michael Cohen, he was going solely on Trump's team's statements about me. What he completely ignored, as a guy that has never met me, I think I've been in his courtroom once or twice, maybe. Instead of listening to what Judge Engoron said on page 43 of that 92-page decision, Michael Cohen told the truth. He decides to go the exact opposite route. Why? Because I am critical. You know this to be, because we've had conversation offline too. I am very critical of the Southern District of New York, as well as the judges. Some of them, not all. Jesse Furman just found himself on that same list. But then again, like I said on MSNBC The Weekend with Michael Steele and Alicia Menendez and Simone, it's one trust fund baby protecting another trust fund baby. That's how he got the appointment. His dad left him like $600 million. Does he have a sense of reality of what was going on in that courtroom? There's a $500 million decision that came out as a direct result of my testimony, and I'm coming in with baggage? Yeah, I know what I pled guilty to. I know what I said. I mean, the whole thing to me just really infuriates me.
Yeah, well, Michael, listen, it's no surprise that you have baggage. You are the first one to admit that, I committed crimes. And I committed crimes in part at the direction of and for the benefit of Donald Trump. I mean, anybody who is in that situation is going to have what we would refer to as baggage. But the key is the person telling the truth? Is the person corroborated, right? For gosh sakes, there's an audio recording corroborating part of it. There are checks corroborating part of it. There are contracts corroborating part of it. There is witness testimony from others corroborating part of it. So, of course, there's baggage, but that
everybody comes with
everybody's
baggage.
got baggage.
I like how everybody now it pretends that they're holier than thou, right? You would come with baggage. My mother and father would come with baggage, and they're the sweetest people on the planet. You walk down the street, every single person has some form of baggage that comes with them. In fact, a buddy of mine sent me a quote, and it was kind of just like maybe to relieve some of the anxiety and stress that I'm feeling. And he sent this quote: "The bubble of 1,000 lies is burst with the power of the truth." And basically, that's the point. I'm going to go in there like I did with the Attorney General, like I did before the Mueller team, like I did before the 7 various different congressional committees, and tell the truth. There's questions, there's documents. I don't call myself the key witness. I say I'm the narrator of the story.
Michael, here's the best predictor of where this case is going to end up. And as we all know, you can never predict with any certainty what a jury is going to do with a case. Because I've always said, getting 12 people to agree unanimously on anything, where to go to lunch, is a challenge. Trying to get 12 people to agree unanimously to a person's guilt beyond a reasonable doubt, one of their peers, because it's a jury of Donald Trump's peers that will be judging him. They're the judges of the facts in this trial. It's a challenge, but in my experience, the jurors also generally take their oath of jury service seriously. And even though everybody's going to walk into that courtroom with some preconceived sense or some ideology or some political affiliation or some feeling about Donald Trump one way or another, they are all placed under oath and they have to swear that they can set aside whatever their own preferences or ideologies or political affiliations are and decide the case based only on the evidence they see introduced during the course of the trial. And for 30 years, I saw jurors do it. And I think the jurors in Manhattan are going to do it. But here is the best predictor. Donald Trump said he didn't do anything to E. Jean Carroll. He did nothing wrong. Well, jury number one disagreed with him. Jury number two disagreed with him. He said, I didn't engage in any business fraud, in my dealings in New York. Judge Engoron disagreed with him and, banged him out for $464 million. So every time Donald Trump's claim of innocence is put to the test in a court of law where the rules of evidence apply, because the rules of evidence don't apply in the court of public opinion, that's the only place he can fool anybody. And think about it. He doesn't fool anybody unanimously in the court of public opinion. All he does is fool the people who are gullible enough to buy into his nonsense, right? So once it's put in the hands of a jury, Donald Trump loses over and over and over and over again. And I fully believe, though we can't predict with certainty, he's going to lose this one too, because the evidence is strong and because I do happen to believe you're going to tell the truth, you're corroborated, and, let them bring on the cross-examination. You're going to be able to field it.
Yeah, look, I agree with you. But let's stick with the jury for a moment, because jury selection is taking place as we speak, 5 hours delayed. I mean, a good half day has already been lost in terms of this, what I have always said is going to be a 3-week process. Everyone say, oh, it's a week or two. There's going to be the same nonsense day in and day out by Blanche and Necklace with Trump sitting there and so on. But do me a favor. Tell my listeners just how important the jury is in a trial like this. And how hard do you think that it's going to be to seat a jury in this specific case?
I've always said you can't win a case in jury selection, but you can sure lose a case in jury selection if you don't do it right. If you don't disqualify people who can't sit fairly and impartially for one reason or another. So jury selection is all important. And, on the one hand, it's going to be a challenge because of who Donald Trump is and what he has done to the American people and to our democracy. It's going to be hard because there are going to be people who, think he is everything that's wrong with our country and our government. That happens to be my view as well. He's not everything that's wrong. The Republican Party is a lot of what's wrong for propping him up and refusing to have the courage to walk away from him and announce that he's trying to destroy our democracy like Liz Cheney and Adam Kinzinger did. Mitt Romney does from time to time. But there aren't a lot of Republicans out there who are standing up for democracy. Instead, they're cowering to Donald Trump because they don't want to lose the 25 or 30% of the voting population that, for whatever reason, has hitched their wagon to Donald Trump. But I actually think Judge Merchan did something that is wise, but is not the way we ordinarily approach jury selection. We generally don't let jurors self-select if they decide they can't sit, right? But because of, I think, the strong feelings that many people will have about Donald Trump one way or another, Judge Merchan has basically said, listen, if you tell me you don't think you can be fair, bye-bye. We'll get you for jury selection next time around. Ordinarily, we don't do that. Ordinarily, we will kind of press appropriately, professionally. We'll press every juror. Well, why do you think you can't be fair? Well, are you saying because you have strong let me give you an example. Let me just take it out of the Trump realm for a minute. When I was doing murder cases, we would have people who say, if this murder was committed with a gun, I am so anti-gun to my core that I don't know that I could be fair, right? Now, what I would ask that juror is, so are you listen, you're allowed to have your personal beliefs about guns. Everybody is allowed to have their strongly held personal beliefs about guns. But are you telling me that if you thought that the evidence the prosecution introduced during the course of the trial did not prove this defendant guilty beyond a reasonable doubt, you would vote guilty because you feel strongly about guns. And most jurors, if they're being honest and thoughtful, will relent and they'll say, well, no, I wouldn't vote somebody guilty just because I despise guns. Well, now it looks like you're actually qualified to sit as a juror, even though you have strong feelings about guns. That's the way we rehabilitate jurors when we go through the voir dire, the jury selection process. Judge Merchan said, we're not going to try to rehabilitate anybody. Yep. If they say, I have strong feelings pro or con about Trump, go, you're excused. Thank you for coming to court today. I think that makes some sense. I actually think that will reduce the amount of time that they will otherwise spend in jury selection.
Well, they've already
sent
out 1,500 forms. And they're bringing them in hundreds at a time. So yeah, I'm with you on that. But I'm totally in agreement with you. I've never seen it where a judge says, if somebody does not want to sit, then see you later. Have a nice day. We'll find somebody else. Have you ever wished that you had whiter and a brighter smile? Well, before you visit a dentist, you should know that their whitening treatments, they're very expensive. And you know what? It's not just the price. You also have to book the appointment, schedule time away from work or family to sit in a dentist's office chair while undergoing this procedure. It's a hassle. Fortunately, now you can try Smile Actives at home or anywhere, anytime. Smile Actives offers a safe and an affordable alternative to those expensive whitening procedures. You see, I've had past experience with these whitening agents, and I got to tell you, I hated it. It causes these zingers afterwards. It's really uncomfortable. And I'm a big coffee drinker, and so I hate to say it. Your teeth get stained. But that's why it's so important to use Smile Actives, because it brings you a bright smile, and a bright smile makes a good impression. Smile Actives makes a teeth whitening gel that can simply be added to your toothpaste every time that you brush your teeth. So there's no change in your routine, there's no extra time, and there's no messy strips, trays, or lights. Simply add Smile Actives Pro Whitening Gel to your regular toothpaste. It's been formulated with polyclean technology to boost stain removal and deliver active whitening ingredients into teeth's grooves and crannies so that you get better whitening. 97% of Smile Actives users in a clinical trial reported up to 6 shades whiter on average. Listen to what I just said, up to 6 shades whiter on average, and all within 30 days. I mean, that's the kind of trial that I like. So what are you waiting for? Start getting comments on your whiter, brighter smile in just days. So visit smileactives.com/Cohen today to receive a special buy one, get one free offer with auto delivery, plus free shipping and handling. That's smileactives.com/Cohen. Terms and conditions apply. See site for details. That's willing to invest the time or willing to be a juror in this case. One time when I received jury duty, and this, of course, was before the incarceration, I'll never forget, the judge did not really want to hear anybody's issues about, I got work, I got kids, I got this, I got that. Wasn't interested. He says, is there anybody here that feels that they cannot sit on this trial? So I raised my hand. And I could see the judge was exasperated with it. And he says to me, jury number, and your number is? I said, I like number 31. So he goes, juror 31, why can't you sit for this? I said, I know the defendant. So he goes, really? So I said, yes, it was a real estate. It was a real estate company that was being sued. And it was pretty significant. And I said, yes. I know the entire family from my hometown, from growing up in school, and also from doing business. He goes, you're excused. and that was that one. But yeah, for the most part, they don't allow that. But I do also want to then press this and ask you, what happens if a juror with an agenda actually does slip through? Because everybody is coming in with some idea or some knowledge as right or wrong as it might be, they have some knowledge regarding this case. Do you think that one bad juror can derail the entire trial? So, for example, if like 11 of the 12 jurors believe one way and one juror does not, explain to my listeners what happens.
Yeah, so I've contended with this exact situation several times in my career. So it depends. First of all, can a mole slip through the cracks and make their way on the jury? Can they fool everybody and come across as fair and impartial and having no agenda at all, only to be hiding their true agenda? Of course, it's possible, right? I don't think it's especially likely for a couple of reasons. One, in my experience, once that juror takes the oath, subject to the penalties of perjury and contempt, to tell the absolute truth during jury selection, that impresses most people. Most people don't want to catch a charge because they're lying to a judge under oath about whether they can be fair and impartial. Two, the names of the jurors are being given to the defense and the prosecutors, even though it's an anonymous jury. I tried 2 cases with anonymous juries, and I didn't even know their names. The parties didn't get their names. It was the most dangerous RICO organization we ever prosecuted in D.C. And I'm sorry to say that some of the jurors were still gotten to by some of the associates of the defendants, and we had to dismiss jurors during trial. And I'll get to what that looks like in a minute. And 3, when the parties get the names, I have to believe they're going to go scorched earth looking at whatever online presence these people have. Because if somebody comes in and says, I can be completely fair and impartial, I have no strong feelings, and they're all over the social media accounts saying MAGA all the way or I hate Trump, well, now we just caught them in a lie, didn't we? So they're going to be excused. They're going to be removed before the jury is seated. Now, what happens if a mole makes it on? It depends on when it is discovered that a mole made it on. Before the case goes to the jury or after the case goes to the jury for deliberations. Before the case goes to the jury, if there is evidence that a juror has done something that disqualifies them, then the judge can conduct a hearing, which can involve individual questioning of all 12 regular jurors one at a time to see what in the world has happened with respect to this one juror that might disqualify them. And before I continue along those lines, jurors fall out all the time. Somebody gets in a car accident when they're heading to trial one day and they're in the hospital. Obviously, that juror can't continue to sit. So you release that juror and you replace them with an alternate who's been sitting in the courtroom the whole time watching the proceedings. So that is kind of a seamless instance where you get rid of one juror and you put another juror on, right? If it's for misconduct because somebody is discovered to be a mole, in other words, they lied during jury selection, before the case goes to the jury to begin deliberations, it's a little bit easier to dislodge somebody who has revealed themselves as being disqualified for some reason. After it goes to deliberations, it gets dicier. And here's why. What we never want to do as a system is kick off a deliberating juror who has a firmly held belief based on the facts, based on the evidence that is different from the 11 other jurors, right? Whether for guilt or whether for not guilty. You don't want to kick somebody off because their assessment of the evidence differs from their fellow jurors. But you can kick them off if they do something during jury deliberations that disqualifies them. We had somebody in one of our RICO trials who refused to participate in deliberations, literally just sat in the corner with his arms folded and refused to participate, refused to engage, wasn't participating in straw polls. Well, guess what? That juror has disqualified themselves from continuing to serve. And we had to go through a painstaking evidentiary hearing questioning each juror to make sure the judge had a factual foundation to remove that juror. Then what you do is you only have 11 jurors. Sometimes the law will allow a jury to proceed to a verdict with 11, but sometimes the judge will take an alternate, bring them back, somebody who sat through the whole trial but didn't participate in deliberations, and then the judge gives the jury an instruction. Everything that y'all just discussed in deliberations before we remove this jurors, you have to put out of your mind. And you now, all 12 of you, with the new alternate who has replaced the dismissed juror, you have to start from jump, go back to square one, and your deliberations must begin anew. And it's now like you got a brand new deliberating jury. I've been through that exercise several times as a prosecutor.
Got it. So let me just move to a different topic here, and that's the gag order that Judge Merchan placed upon Donald about a week or so ago. Stop talking about his daughter. Don't talk about court staff. Don't talk about prosecutors. You can't talk about witnesses and so on. And then all of a sudden on Truth Social, right, he puts out multiple different posts. But the one I want to bring up is this one. Has Mark Pomerantz been prosecuted for his terrible acts in and out of the DA's office? Has disgraced attorney and felon Michael Cohen been prosecuted for lying? Only Trump people get prosecuted by this judge and these thugs. A dark day for our country. My question to you, does that sound to you like Trump violated Judge Merchan's gag order? And they're talking about $1,000 as a fine for each of the 3 posts that he puts out. Now, I want to be very clear about something. The damage that Donald Trump does with a post far exceeds $1,000 in the person's life that he is attacking. It's very, unless you've been the subject of one of them or multiple of them, as I have, you can't even begin to imagine. So first, all right, do you think that he did violate Judge Merchan's gag order? And we're going to find that out sometime next week when they're having a hearing onto it. And do you think that the $1,000, is that standard and routine in terms of the fine that's imposed?
Yes, I absolutely think he violated the gag order, and it doesn't seem like there is any wiggle room on that issue. And I know the DA has already asked for a show cause hearing and wants him to be held in contempt 3 times. $3,000 total fine assessed for the contempt, which obviously doesn't mean anything to Donald Trump. And I am troubled, to put it mildly, that they're not even going to take up this issue until originally it was going to be a week from Wednesday. Now I think it's actually, the DA has asked that they do it on the morning of the 23rd at 9:30 a.m. before court starts. So what is that? More a week and a half down the road. That's a problem because you don't let somebody violate court orders, gag orders with impunity. You jump on them with both feet, figuratively speaking. You hold them accountable. And, you know, the monetary fine won't mean anything, but I believe the monetary fine will be a precursor. I believe Judge Merchan, once he holds the requisite hearing, we'll talk about that in a minute, will hold him in contempt, will fine him, and will probably say the next contempt violation will land you in jail. Now, the New York state law says $1,000 is the maximum fine for a contempt of court, but 30 days in jail is also available for each contempt of court. Here is the only reason Judge Merchan couldn't do it today. The New York state law, specifically Judiciary Law Section 751, says if the contempt was not committed in the judge's presence, in other words, if you didn't actually commit the contempt in the courtroom with the judge having eyeballs on it, there has to be notice and an opportunity for hearing. So if it had been me, I would have urged Judge Merchan to do it on this Wednesday when there is a down day, because the court is only sitting Monday, Tuesday, Thursday, and Friday. I would have said, Judge, either let's do it at the end of jury selection today, or at the latest, let's do it this Wednesday, because you can't let this defendant continue to thumb his nose at judicial authority. You can't. It undermines the rule of law. It endangers witnesses.
Yes. With all due respect to the judge and to everybody else here, you really can't even begin to imagine what happens to the witnesses. And I know this because I happen to be the one that's here. Look, I'm under subpoena. I keep talking about this. I am not a guy who said, please, call me as a witness. I want to be a witness in this case. I don't want to be a witness in the case. And if they would tell me tomorrow, you know what, you come with too much baggage, we're not going to use you, we're just going to use your documents, I would say thank you very much. Have a great day. I wish you the best of luck either way. It's not my fight, it's your fight. When he does this and he knows the gaslighting and the dog whistle blowing that he's doing to his MAGA supporters, he puts my life in jeopardy. And the fact that it's now 10 days, 11 days before which we're going to end up having a hearing regarding his behavior, which he knows exactly what he's doing. He knows exactly what he's doing. And you're right, he's sticking his thumb in the judge's face. He doesn't care. And in fact, I don't think he's going to stop. I think he's going to actually press Judge Merchan to do something more than hit him with the $1,000 fine. Because that $1,000 fine, as you rightly stated, doesn't mean shit to him. Because this second, he just raised $1,000 from a bunch of his MAGA moron followers. I don't, it's just obstruction of justice. It's witness tampering, and it does have to stop. When is it going to stop? When somebody gets hurt?
Yeah, no, I don't think it's going to stop. I think the only way it would stop is if he started to get consecutive 30-day stints in jail for it, as the New York law allows. But listen, this is all fundraising for him. This is all fun and games for him. I mean, listen, one of the
it's not fun
positive
for me.
developments, no, it's not fun for the witnesses. And Michael, you know how many witnesses I put in witness protection over the years because their lives were at risk because of what the defendant or the defendant's criminal associates were doing. And what Donald Trump did a couple of days ago is he gave a command to his foot soldiers. What did he say? All hell will break loose Monday outside that courthouse.
Yep.
That's not him ruminating. That's a command.
It's a dog whistle.
The good news is all hell didn't break loose. In fact, when you looked at the people who were gathered outside the courthouse, it looked like all accountability was breaking loose with all of the signs about confining Trump, hold him accountable for the crimes he committed. So, but yeah, he is in the business and the habit of endangering every person who is involved in the endeavor of trying to hold him accountable for his crimes. And it's a significant failing of our institutions of government that we have not done to him what we would do to any other defendant on pretrial release in a felony case and detain him pending trial, because he is a danger to the community. We've turned a blind eye to that. And that is, really an embarrassment to the equal application of the laws, in my opinion.
Yeah. Speaking about this Untruth Social platform, I don't know if you've seen it. You remember they were talking about, Donald, the day that it went public, Donald has $6 billion worth of stock of the company's worth $6 billion, whatever the hell it is. I don't know if you've seen this, but the stock is down to $26.60. It's down like 70% since its opening. $26.60. Today, it's already down $6, which amounts to about 18.5% just for the day. And it'll probably close even lower because every single day, this would have been a great stock to short. The only problem is you couldn't even get anybody that would take the short. You could put your order in, but unless the order gets fulfilled, you can't even put the short in, believe it or not. Everybody knew that this meme stock was garbage. Not only is that garbage, so is what he puts onto it, including all the attacks. There's only one problem. The people that are actually on it, the couple of million people, they're crazy. And they listen to Donald, and they listen to when he blows his dog whistle and he starts to gaslight. Unfortunately, like I said, some of us are on the wrong side of that group. And Donald is doing this absolutely on purpose. And I do hope that Judge Merchan imposes something more than just $1,000 fine, so that I don't have to, like today when I was walking to the post office, you had people, yelling at you from their cars. I mean, this is just unfortunate what happens. What happens when that person now, and it's happened to me before, gets out of the car and wants to make it physical, right? I'm not allowed. I can't. What am I supposed to do here? I'm still on paper, thanks to, of course, Judge Jesse Furman. I'm still on fucking paper. But let me move on and ask you this then, because the Supreme Court is hearing a challenge to a federal law that makes it a crime to obstruct or impede an official proceeding. Now, the law has been used to charge hundreds of people in connection with the January 6th insurrection, and it was also used to charge Trump in his election interference case in D.C. If the court rules against the law, will charges against Trump be dropped? And could
Not all of them.
And what about could currently imprisoned J6 rioters all of a sudden be released?
So it's not a one-size-fits-all answer. My reading of the statute says, or otherwise obstruct Congress or an official congressional proceeding. This fits the bill. My concern is I don't have any confidence in our Supreme Court. The Supreme Court has proven that it's not sort of an honest broker of the law. So I don't know. I can't predict how they're going to rule on this. I sure hope they uphold the constitutionality of the statute, because I think that's the right answer. But what will happen is if they strike it down, any of the J6 defendants who were convicted on, and most of them are convicted on multiple counts. So this one count would end up being vacated and no longer being a good count of conviction for the people who had been convicted of it. Then they would have to be brought back for a resentencing on the remaining offenses of conviction, and their sentence might end up being reduced as a result of that statute if it's thrown out. But that statute is not the only thing that Donald Trump is charged with. He's charged with 4 felony offenses. So it may affect one of the charges, but it wouldn't affect all of them. And ultimately, Jack Smith would pivot and he would continue in his prosecution in D.C. against Donald Trump for trying to overturn the election's results. But of course, the Supreme Court has brought that case to a screeching halt by deciding to actually discuss whether a president should have absolute immunity while in office, should be able to commit all the crimes he wants against the people of the United States and never be held accountable, never be prosecuted. Again, in any sane version of the interpretation of our Constitution, that doesn't even get taken up by the Supreme Court because it's laughable. The reason I say it's laughable, Michael, is because the impeachment judgment clause says, and I'm going to paraphrase here, that somebody, a president, can be impeached by the House of Representatives, convicted by the Senate on the articles of impeachment, and can still be prosecuted for the exact same conduct for which he was impeached. How in the hell can you take that language and say a president can never be prosecuted? He can even be prosecuted after he's impeached. So what the Supreme Court is doing with this case, other than they might want to be the big dogs on the block, they want to be the ones to issue the historic opinion rather than leaving it to the D.C. Circuit Court of Appeals, which frankly only binds, the D.C. Circuit. So it would still be an open question potentially in other federal circuits. So I just hope to hell the only reason they're taking it up is to put a damn exclamation point on the trial court ruling and the D.C. Court of Appeals ruling that it ain't a thing. There's no such thing as presidential immunity.
If they go ahead and they grant presidential immunity, let's say hypothetically they really get their act together, and by the end of this month, there's a 100-page decision on presidential immunity, and they grant presidential immunity. Just imagine that. Doesn't then that give Joe Biden the ability to do whatever he wants as well? Why can't he do the same things, for example, that Trump is talking about? He's going to call out SEAL Team 6, have them show up to Mar-a-Lago, right? Walk right through the Secret Service that's there, right? Because they're going to come in with an army of 200 and grab Trump, bag him, tag him, bring him off to Guantanamo Bay, which he likes that name Gitmo. You know, it's like a name that's on the, we'll send him off to Gitmo. They'll all be off to Gitmo, right? All of the lousy, radical, the radical left. I mean, it's like, couldn't Joe Biden then do the same thing?
Yeah, so he probably wouldn't because he's a law-abiding president. But this is a thought experiment, and I've talked about this in the past. If you literally have a Supreme Court who says all presidents can commit all the crimes they want with impunity, they can never be prosecuted, then the question becomes, if we're going to have a dictator, because that is what the Supreme Court will convert the presidency into, do you want an evil dictator or do you want a benevolent dictator? Joe Biden wouldn't have to leave the White House because what they're saying is Donald Trump can't be prosecuted for trying to break the law to retain the power of the presidency. So that means Joe Biden can do it too. I don't think he would, but we're in the realm of the absurd now with these conversations we're having. Most people I talk to say, there's no way the Supreme Court will do that. But you know what they might do, Michael? They might say, well, there may be outer perimeter presidential immunity. So what we have to do is give it back to Judge Tanya Chutkan. You have to now hold all kinds of hearings to decide which of the acts alleged in the indictment might qualify for outer perimeter absolute immunity. And if they do that, then we're not going to go to trial against Donald Trump in D.C. until 2026. Who knows?
Right. Okay, I understand that. But let's just play this out because I know it sounds stupid. It's like a really bad episode of like House of Cards. But imagine if the Supreme Court does grant presidential immunity. And Joe Biden agreed, right? He's an honest, president. He loses the election. Well, he's still president until the inauguration in January. And he goes, yeah, I don't think that's going to happen. And then they end up, like I said, they go to Mar-a-Lago, they grab Trump, they bag him, tag him. He's never able to be inaugurated as the president. Biden decides that he's going to remain in office because he could do whatever he wants. He has full presidential immunity, and we'll take the topic up down the road. Oh, by the way, since I have full presidential immunity, I've also decided that I'm going to do what Trump said he was going to do. I'm going to rewrite the Constitution. I'm going to disband the tripartite system of government. I'm going to turn around and get rid of the powers conferred to both the judiciary and the legislative branch. So there's not going to be anybody to turn around and try to pass a bill or even to introduce a bill that's negative to my presidential immunity complete power. On top of that, there is no more Supreme Court because I just disbanded it, and all power is conferred upon the executive branch, meaning to the chief executive, to the president, who then becomes the king. And I'll tell you what, I'm going to pick and choose who I want to be my successor. And then that successor gets the presidential immunity power as well. And there goes our entire democracy. That's kind of how I see it.
Yeah. And that, unfortunately, is the result. If the Supreme Court says a president can do whatever he damn well pleases and can never be prosecuted for it. I mean, there's a fundamental sort of question. I was a football guy. My pop was a high school football coach in New Jersey. I played football through college. And if you asked me the question, what is the right thing to do if one team is permitted to violate all the rules and never get a flag thrown, but the other team has to play by the rules or chooses to play by the rules? Well, then it's going to be a one-sided game, isn't it? So, but is the answer both sides have to basically violate the rules and it's now a free for all, right? Not only can you hold and clip, but you can bring bricks and bats and knives and guns onto the field, right? Then what you have is you are setting up an American revolution. Yeah. If both sides can commit all the crime they want to retain the power of the presidency, you're setting up the next American revolution.
So let me ask you then, do you think that Judge Tanya Chutkan will get to start her federal election fraud trial before the election, or you think it's already too far gone?
You know, there is a slim chance that she will. Listen, if they decide the case, first of all, this term, which they don't have to, I believe they will. Let's say they decide it June 1st. I'm just going to make it up. Then it can still go back to Tanya Chutkan, and she can still give the parties 2-3 months of run up to the trial date. She's pledged that she would give them the same amount of time that they had when the Supreme Court put a stop to it. Between that date and March 4, when the trial was supposed to start, was 88 days. She said, once I get the case back, I'll give you all 88 days. She doesn't have to. She can whittle that down to 60 days if she wants. And then in theory, if she gets it back on June 1st, he could still go to trial, right? In August. It could happen.
Yeah. It would
Will
have to
it
be
happen? Yeah. Will it happen? Who the heck knows?
Yeah. No, I certainly don't. That's why I was asking you the question. Yeah, you're a lot smarter at this than I am. So let me then move on to Trump's stolen documents case. I mean, do you not find it as comical or ironic as I do that this guy has 4 criminal indictments against him, and we're still talking about him being the possible next president of the United States? I'm just really wondering what the hell is going through people's minds right now. But while we're all pondering this incredibly stupid type of a question, I want to move on to Trump's stolen document case. In your opinion, is Judge Cannon stupid, or is she just crazy like a fox? Because she has helped delay the trial in every possible way. And it can't possibly start on its original date, May 20th, right? And Jack Smith has asked to move the trial date now to July 8th. But she has not set any sort of a timeline. Why? What am I missing here? Can you make me smarter?
So she's clearly incompetent. She's not up to the task. All you have to do is read her 2 proposed jury instructions, which have just a fundamental misunderstanding of both the Presidential Records Act and our espionage laws. She's clearly incompetent. Is she also compromised? It's very hard for me to believe that every mistake she's made, that every decision that she has made to the benefit of Donald Trump, including one that the 11th Circuit Court of Appeals said, Judge, you abused your judicial discretion. You did something for Donald Trump the law does not allow. You interfered in a Department of Justice investigation into these documents that were seized from Mar-a-Lago. I don't know how many times she has to engage in that kind of conduct before we reasonably conclude she's also compromised. She's not just incompetent. So the only disappointment from my perspective is we haven't seen a motion to recuse, because regardless of how the 11th Circuit ultimately decided the issue, whether she should be removed from the case or not, without a fully litigated motion to recuse and an appellate court decision, we can never have confidence in the outcome of the trial. And that is the goal of everything we do. It's to give a defendant a fair trial, to give the people a fair trial, and to give the public confidence in the outcome of the trial. So I think a motion to recuse has to be brought, has to be litigated, has to be, has to go up through the 11th Circuit Court of Appeals, and we need a definitive decision on it. I believe she should be removed. Why? Because I understand the language of the federal law that applies to the removal of federal judges. If a judge's impartiality might, low standard, might reasonably be questioned, the judge shall recuse themselves. Her impartiality might reasonably be questioned, and it is reasonably being questioned every day. She's no longer qualified to sit And I hope Jack Smith gets to a point where we get to litigate that issue and see the result of it.
Well, he's going to need to do that ASAP because, if again, this case will never see the light of day before the election. That's certainly for sure. But moving...
Not with her presiding.
No
Not
chance.
with her presiding.
So last week, attorneys for Walt Nada and Carlos de Oliveira, they're both still employed, by the way, at Mar-a-Lago by Trump. They argued that the charges against them should be dismissed, and Judge Cannon shockingly denied the request. But do you think that de Oliveira will flip? And if he does, what do you think will be the outcome of that case?
I think he will only flip if he gets conflict-free counsel, right? Look at what happened to Yuscil Taveras. I think that was the former IT director down at Mar-a-Lago. He had a Trump world lawyer. He went into the grand jury, reportedly, and lied to try to cover up Trump's crimes. He then got conflict-free counsel after that issue was litigated before Chief Judge Boasberg in D.C. The minute he got conflict-free counsel, a woman named Shelley Peterson, the number 2 person at the Federal Public Defender's Office, a wonderful defense attorney, he's like, oh, I have a lawyer representing my interests? I retract my lies. I want to go back in and correct the record and tell the truth about what I know. That's why the Sixth Amendment right to counsel is so damn important. It provides not only do you have a right to any old counsel, you have a right to conflict-free counsel. And when Taveras got it, he did the right thing. I think Nauta and de Oliveira are stuck unless and until they get conflict-free counsel.
But again, they should not be stuck because counsel is misguiding them. You know, I had that whole issue with Bob Costello. I mean, obviously, you know, I knew exactly what Costello was up to. It's very similar to, you remember when Trump was required to provide, and he was president at the time, responses into a series of interrogatories, and they mirrored them to, I think it was either Steve Bannon or Paul Manafort. It was one of those two clowns. And they mirrored it by doing it. And you weren't, of course, supposed to speak to anybody else in terms of this, but they ultimately did. Walt Nada, Carlos de Oliveira are not blind. They're not deaf. And neither of them are dumb. They see what's going on. They've seen what's happened to people like myself. They see what just happened to Peter Navarro. Is that what they're looking for themselves? So if somebody is telling you, hey, yeah, it's not a problem. You could easily jump off of a bridge and you'll be fine. You know, it may hurt the bottom of your feet, but you'll be fine. Trust me. I think that they're smart enough to realize that whole trust factor, when you're asking someone to stick their head in the guillotine, may not really be smart, and it may not be worth the job at Mar-a-Lago. You agree?
Michael, not everybody is strong enough to break away from the mob boss and flip on him. You know how many times I approached somebody that I really wanted to develop into a cooperating witness, and they were so scared for themselves and their family members at what would happen if they flipped on the biggest criminal fish that they wouldn't do it. They said, look, I'll take a soldier plea. A soldier plea is when you walk into court and plead straight up to every count in the indictment because you're more afraid of what will happen to you and your family if you flip than if you go to prison for the rest of your life. I couldn't break everybody I wanted to break and bring on board as a cooperating witness. So it doesn't surprise me that some of these people who are very weak, right, who are scared, who are followers, are unwilling to break from the mob boss. That, you know, we see that all the time.
Yeah, well, maybe you should then speak to Tom McKay, Nick Roos, Andrea Griswold, Jeffrey Berman, Robert Kazami. They'll tell you exactly how to do it. Just go after their wives, right? And threaten to put their wives away, too, on an 80-page indictment. Fucking assholes. So anyway, look, Glenn, the hour goes by very quickly here on Mea Culpa. I have one last question for you. And again, it still deals with federal judge Eileen Cannon and the Supreme Court. And they're just ready to hear arguments for, again, Trump's presidential immunity claim. Treat Jack Smith like he's the enemy. and not on the side of law and order. I'm so blown away by this. You have Eileen Cannon, a federal judge. You have the Supreme Court on the other hand. They're supposed to be they're the epitome of the law, treating Jack Smith like he is the enemy and not on the same side that they are on. Will these judges be able to hear Smith's case without, or with any objectivity? I mean, can he as a prosecutor get a fair trial? It's so funny to say it because as we speak, Trump is already yelling and screaming that he can't get a fair trial in Manhattan at this DA trial that's going on right now. I see it completely different in this case. I don't see Jack Smith with Eileen Cannon and even, I hate to say it, the Supreme Court getting a fair trial.
I don't think Judge Eileen Cannon can sit as a fair, independent, and impartial judge. So I don't expect a fair trial based on everything that we've seen from her. I think you have to go judge by judge. I tried cases against Judge Tanya Chutkan when she was a public defender in the courts of Washington, D.C. We had murder cases against one another. I've kept up with her over the years. She's the real deal. She's going to be fair, impartial, no nonsense. I happen to believe if Donald Trump is convicted, she will step him back. She will sentence him to prison time. That's just my personal view of the strength of that case and the judge that Tanya Chutkan is. I think Judge Merchan has distinguished himself to be a fair, thoughtful, no-nonsense judge. I do wish he would take up the gag order violation more promptly. That's my one concern that I have. And, Judge McAfee, who, there's a lot of reporting about him being a Federalist Society guy and all. I think for the most part, he's done a really good job litigating and controlling the proceedings down in Georgia. I have some quibbles with some of what he has said and done, but I think he has actually performed pretty well. So I think it's a judge, and the Supreme Court, all bets are off, because I think there are some judges who are they're waist deep in corruption, financial corruption. They have violated our financial disclosure laws, which were the bane of my existence when I was a career prosecutor. We had to fill them out every year, and they're very burdensome. But God forbid, I was sure not to put a decimal in the wrong place because I didn't want anybody to think I wasn't reporting something that I should have been reporting. Clarence Thomas doesn't care. Alito doesn't care. Plus, all of these justices lied about Roe v. Wade. They said in their confirmation hearings, has nothing to worry about from me. Settled precedent, stare decisis, affirmed several times over, nothing to worry about. Then the minute they had the opportunity, what did they say? It was egregiously wrong from the moment it was decided, which puts the lie to their confirmation testimony. So I have no confidence at this point, unfortunately, in the Supreme Court.
Glenn Kirschner, thank you so much for helping me to be smarter today. Thanks for joining me here again on Mea Culpa. Really appreciate you, everything that you do, and I love watching you on social media platforms.
Thanks, Michael. Appreciate it.
I'll see you soon, my man.